Okay, here we go. Hello, everyone. My name is Dr. Marty Kotler. Thank you for attending. Today's topic is social media and HIPAA. Just a few things here before we get started. There's no audio taping or video taping allowed, and any unauthorized reproduction, dispensing, forwarding, or copying of this target coding presentation is illegal. The information in this presentation is for educational purposes. It's not intended to be legal advice. The laws, rules, and regulations regarding a healthcare facility vary greatly. They're constantly changing. We don't provide legal services if you need an attorney, and there are a few things during this presentation that you should check with an attorney on. You should attain an attorney, especially some of the labor laws that I might touch on in today's presentation. Target coding assumes no liability for the data contained in this presentation. The presentation provides information in regard to the subject matter. Every attempt has been made to make certain that the information in this presentation is 100% accurate. However, it's not guaranteed. Now, just a little bit about myself. If you're a member of Target Coding, hopefully you know who I am. If you're not, let me tell you a little bit about myself. Again, my name is Dr. Marty Kotler. I'm a chiropractor. I'm a certified professional compliance officer. I'm certified in CPT coding. I've written many books on billing, coding, and documentation for chiropractors. I write articles for chiropractic economics and dynamic chiropractic and many state association newsletters throughout the country. I'm a speaker for many organizations like the Coding Institute, Parker Seminars, Foot Levelers. Plus, I speak at many national and state chiropractic association conventions nationwide. By the way, anybody listening to this presentation, if you're part of your association that's looking for a speaker on HIPAA compliance, coding, audit prevention, billing, documentation, let us know. We may be able to get a sponsor and do a nice presentation for your group without charging any money. So let us know if you're interested in that. All right, here we go. Social media and HIPAA. First, let me give you a brief update on what HIPAA is all about. First of all, is it HIPAA? Is it HIPPO? Is it HIPAA with two A's? Is it HIPAA with two P's, right? I see a lot of typos on this. It's HIPAA with two A's, and HIPAA stands for the Health Insurance Portability and Accountability Act. It's been around a while, signed into law on August 21st, 1996. It's been updated and things have been added along the way over the last 20 years. HIPAA compliance is not voluntary. Let me repeat, HIPAA compliance is not voluntary. It's mandatory. It's a law. You have to abide by the HIPAA laws. How do you know if you're abiding by the HIPAA laws? Well, first you got to know the laws and the rules to know if you're abiding by them or breaking them, right? So I'll share a few things with you. Again, we don't have that much time today, only about 30 minutes, but I'll try and give you as much as I can. So HIPAA applies to all healthcare providers. Healthcare providers are considered covered entities. You might hear me use that term. You are considered a covered entity. I am going to assume all of you are covered entities. If you are not, then if you don't think you are, then get something in writing, get some sort of letter from the federal government that you've been excused. I do have one client in Illinois that has gone through this, and he is exempt from HIPAA, but he didn't decide that on his own. He had to get something in writing, a formal letter that he's been exempt from HIPAA. But let's assume all of you are HIPAA covered entities. HIPAA has two major parts to it, the privacy rule and the security rule. Privacy rule applies to all PHI. PHI, you're going to see me use that term a lot. It stands for protected health information. So the privacy rule applies to all PHI, all protected health information, all patient protected health information. The security rule applies specifically to the electronic transmission, whether it's at rest or in transit, PHI. So security rule applies specifically to electronic PHI. So the privacy rule, the purpose of it is to protect patient data and regulate how providers can use and disclose PHI. You need to protect your patient data, and it's not just about protecting the patient's diagnosis, why they're coming in. There are many items that you need to protect. HIPAA calls them IIHI, individually identifiable health information. And examples include the patient's name, address, date of birth, phone number, fax number, email, social security number, medical record number, health plan ID number, account number, license number, auto vehicle identification number and license plate number, website, your IP Internet Protocol number, fingerprints, full face photo. For example, many providers will take a copy of the patient's license. Well, that has a full face photo on that, so you need to protect that. And any other unique identifiers or items like the patient's diagnosis. Now, little graphic here on the bottom right screen, it says, according to your HIPAA release, this is a doctor talking to a patient, according to your HIPAA release form, I can't share anything with you. It's a joke. Now, some of you may feel that way, that HIPAA is very restrictive. Now, according to HIPAA, it's not meant to restrict a provider from running his or her practice. It's not meant to choke you. It's not meant to prevent you from running your business. It's there to protect you, protect the patient, and there are certain standards that are required. It's not voluntary. Now, a compliance plan that you may be familiar with, like the 7 standards that some other consultants are putting out there, a compliance plan, well, that, depending on who you talk to, is optional. Putting together a standard office compliance plan is optional, in my opinion. But HIPAA is not. It's totally different. A standard compliance plan and a HIPAA compliance plan are 2 totally different items. So, just wanted to clarify that. Now, one of the most important things to do with new patients is provide them with a document called the Notice of Privacy Practices. This is also required, and most of the doctors that I work with have one, and they supply one. But I could tell you 90% of the ones that I review, and that's part of the service that we offer, will review your Notice of Privacy Practices. 90% of the time, they're old, they're outdated, they don't have correct information in it, and it could hurt you. I was actually looking at one of my clients' Notice of Privacy Practices, and he told me that he got it from his brother-in-law. His brother-in-law is a dentist. So my client, a chiropractor, took his brother-in-law's Notice of Privacy Practices and is handing it out to the patients. Guess what? It talks about all dental things in there. It's not something that you just copy and give out. Take a look at it very carefully. So there's one here on your screen, the one that I provide to my clients. This is it, the one that you see. If anybody listening to this presentation would like to get a copy of this NPP, I call it, Notice of Privacy Practices, just send an email to Natasha@targetcoding.com, NATASHA@targetcoding.com, and she'll get it to you. And you know, most of you probably haven't read your Notice of Privacy Practices. It's an important document. It could help protect you, especially with social media violations and any other breaches that may occur. This is a very important document. So your name, your practice name, address, telephone number should be on it. And you're just basically telling patients, you know, how you're going to use and disclose their information. So the patients have rights. That's one of the big updates to HIPAA. It occurred on September 23rd, 2013 through the Omnibus Rule, which had a major update to many things. One of the things was the patient's rights. So patients have the right to get an electronic copy of their record if they ask for one. That's not unusual. If for some reason your computer shuts down, you can give them a paper copy if you can't do an electronic copy. Patients could ask you to make a correction in their record. You might have a patient say, hey, I want to see my file. I had one patient ask me, Doc, I was looking through my record like I had the patient's chart in the room. I wasn't in the room, and I see the patient thumbing through the patient file, and the patient says, you wrote down that I have high blood pressure. I don't have high blood pressure. So a patient is allowed to ask you to correct their record. They could ask you to have confidential ways in which you communicate with them. If they don't tell you, then you can leave a standard message on their machine. I wouldn't get into too much detail, but if you want to leave a message on a patient's answering machine, just say, hi, this is Dr. Smith's office calling. Please give us a call back. Some patients don't want to know. They don't want to let their spouse know that they're going to the doctor. So there are ways in which you can communicate confidentially, give the patient the opportunity to tell you. They might not want you to call them at work. They might not want you to call them at home. They may prefer a text. The patient could also ask you to limit what type of information you share. For example, a patient can say, I do not want you to bill my insurance. I am willing to pay you in full for my services. I am demanding and restricting you from sending my health insurance company any bills. Next, they may ask you for a list of other providers that you've shared their information. They're allowed to get a paper copy of the notice if they'd like. They can choose someone to act on their behalf. They have the opportunity to file a complaint. You're required. I mean, that's not something I love giving someone. It's like if you owned a restaurant, as soon as they walk in the door, you could say, if you don't like the food and you find a bug in your soup, well, here's the place to contact the local health department, right? That's not something you would want to hear as soon as you walk into a restaurant. But when it comes to healthcare, yeah, you have to let them know. If you're not happy with us, here's where you would file a complaint. Not fun, but these are the rules. I don't make up these rules. I just share them with you. And the patients have choices. They have a choice whether, you want to. Now, some of you may want to post on social media that you have maybe a very famous patient, and they're willing to give you a testimonial. They love you. They love chiropractic. Fine. Get them to sign off on something, and the Notice of Privacy Practices addresses it. Other uses and disclosures, you can contact other healthcare providers on behalf of the patient without getting written authorization. So that's in the Notice of Privacy Practices. Some offices waste time. If they get a good quality Notice of Privacy Practices signed, and then a couple of weeks later, a couple of months later, the patient says, well, I am going to another doctor, or, somebody needs my records, can you speak to my medical doctor about my condition? You don't have to have them sign any new forms. That's a waste of time. It's already been taken care of in this document. So you're going to use their information to bill insurance companies, do research. You have certain responsibilities that you're going to maintain and protect their information. If a breach occurs, something happens, your system gets hacked into, you lose a laptop, something happens, then you have an obligation to let them know that a breach occurred. It might not be something that's too reportable. If you have everything in place, the passwords and encryption, you might not have to report it at all. You're telling them that you can change this notice, and they're available to get a new one if they ask. You have to put down the contact person, which is typically the compliance officer, address, telephone number, and then an acknowledgement. The patient has to acknowledge that they've reviewed it, and they have the opportunity to decline signing it. I mean, that's a question that might come up. What happens if a patient looks at this Notice of Privacy Practices and says, I ain't signing that? Do you have to take them as a patient? Can you discharge them? The answer is, you take them anyway. They don't have to sign this in order for them to qualify as a patient. Now, if they don't sign it, then there's another form that you should fill out that the patient has refused to sign it, but you can treat the patient. But to me, it's a little red flag if a patient doesn't want to sign this. So the patient has to acknowledge it. So if you'd like to get our notice of privacy practices, copy of this, just let Natasha know. If you have a good quality one, make sure that it's updated, make sure that it has all the information in there. Other basic things about the privacy rule is, just keep paper files face down, computer screens and files away from public view. Some patients, they come in and they lean over the counter, right? I'm sure, front desk CAs listening to this, you're kind of chuckling. You have patients that they lean over the counter because they want to see what's going on. You know, sometimes, you feel like saying, whoa, Mr. Jones, back up. You can just talk. I could hear you. You don't have to lean over the counter and start pointing at things on my desk, So keep patients away, keep them out of, so they can't see other patient charts. If you walk away, staff members and doctors, if you walk away from your computer workstation, log out, make sure you have screensavers. A lot of chiropractors and physical therapists have open therapy rooms. You got to speak a little quietly. You got to use discretion and open therapy rooms and at the front desk. So here's something that happened on social media. Before we dig into social media a little deeper, this happened not too long ago. Did ESPN violate HIPAA? There's a player, very well-known player for the New York Giants, those of you that follow football. There's a player for the Giants. His name is Jason Pierre-Paul. Last year, he was playing around with fireworks, I think it was, and a piece of his finger was blown off. He went to the hospital. Well, someone at the hospital released information to Adam Schechter. He's an ESPN reporter. Adam got the information from this hospital employee and posted it online. And in the bottom left corner is a picture of the hospital chart that shows Jason Pierre-Paul's name and the procedure that was done. It says right index finger amputated. Amputated finger. Now, do you think Jason Pierre-Paul was happy with that? No. He was very upset. What could he do? Can he sue ESPN for a HIPAA violation? That's the question I want you to start thinking about. Did ESPN violate? Forget about Jason Pierre-Paul. Did ESPN violate HIPAA? You know what? The answer is no. ESPN is not a covered entity. ESPN is not a healthcare provider or a workforce member of a covered entity, but the employee, that's who violated HIPAA. So the employee could be fired, could be disciplined, could have fines. The hospital could be fined by Health and Human Services. Pierre-Paul could sue the hospital for negligence, but did ESPN violate HIPAA? No. So staff members, doctors, there's no snooping. No snooping at other patient, like you may have a front desk staff person that's not authorized to look at patient records. You have a front desk staff member, their job description is to answer phones, make appointments. They might not have the ability to look in patient charts, so they shouldn't be snooping. Now, even if you have your front desk CA does have the authority to see patient diagnosis codes and social security numbers and credit cards, that's fine. The staff member, they're an important part of your workforce. So they have the opportunity to log in. Your billing staff has the opportunity to log in and see patient information. But if the doctor is seeing, let's say, a famous patient on a cash basis, and the patient's coming in, paying cash, seeing the doctor, why would the staff person need to go in there and take a look at that file? If there's no good reason, that's considered snooping. That's a violation of HIPAA. There's no reason for staff members to be looking at patient charts. UCLA Medical Center a few years ago got in big trouble. People were fired. There was some major issues because staff members were snooping at Britney Spears. Britney Spears was at the hospital, and staff members were going in and looking at her chart and then sharing the information with their friends. So there's a little bit about the privacy rule, a little bit about the security rule. Security rule, it sets standards for the protection of electronic PHI at rest or in transit. So at rest is when the patient information is sitting on your hard drive, on your computer systems, and in transit is when you're submitting the claims over the internet. There are 3 safeguards that are important to be aware of: administrative, physical, and technical safeguards. A couple other things. Again, this relates to electronic PHI. Only open emails from trusted sources. Use good quality antivirus software. Keep passwords confidential. Don't use passwords that can be easily guessed. You know what the number 1 password is? It's the word password. So use passwords that are not easily guessed, like your name, 1234, not good. The word password, not good. Use an uppercase, a lowercase. Try to make it 6 to 8 digits long. Use a symbol, uppercase, a number. Don't share your password with anyone. Now let's get into some specific social media. Touched on it a little bit. Now let's get into some specific social media items. So HIPAA applies to social media just like it would apply to any other type of media. Verbal, fax, email. So HIPAA applies to social media just like any other way you would communicate. There's absolutely no conversations that should be going on social media like Facebook, Twitter, LinkedIn, all the other sites, Instagram. No conversations should be occurring about the patient's protected health information. I don't recommend staff members take selfies with patients and then post them. Now, again, if you have a very happy, satisfied patient and they go, I don't mind being a testimonial, I'm happy to, great, do it. Fantastic. Your practice has a Facebook page? Great, fantastic. More and more of my clients are getting more and more patients through the internet than ever before. So have a Facebook page presence, have a website, have all of that. But just remember, certain things you need to stay away from. Breach violations can occur very easily and inadvertently on social media. I recommend you discourage staff members from friending patients unless it's a family member or a close personal friend. As a general rule, I don't recommend doctors friending staff, just like I don't recommend the doctor date patients. Staff members that blog, great. You can blog. Doctors set up a blog. It's a great way to get out there, content on the internet, more Google Analytics, more search engine optimization, all coming to you and your site, getting new patients, having patients come in. There are marketing consultants out there that teach you how to get out there on social media. Fantastic. You might have a blog. Doctor, staff member have a blog, but your blogs, especially if a staff member is writing it, should have a disclaimer indicating that the information expressed is not those of the practice. Set up Google Alerts and other mechanisms to track online conduct. Online reviews. Hopefully you're getting online reviews. You don't have to set up an online review, but I know quite a few of my clients that when a patient comes in, see, back in the day, when a patient came in and said, I love coming in here, Dr. Kotler, you've helped me so much, I would have the patient write a testimonial and I would put it in a binder and it sat in the waiting room. But nowadays, it's different. Nowadays, many of my clients tell patients, do you love coming in here? You're very happy with the chiropractic services? Great. Why don't you give me a good review on Yelp? Okay, great. And that's a great way to get new patients. But sometimes, gotta remember, some patients could give you a negative review. You could be the greatest chiropractor in the world. Some patients may not agree with your approach, or they just might not like the way you treated them or how much you charge them, and they can put a negative review online. So, I mean, some of them could be minor, which shouldn't do too much credibility damage. I mean, your credibility is important. You know, if statistics have shown that doctors that have had HIPAA breach violations have lost 50% of their practice. Patients, just think about it. If the internal medicine doctor that you go to or the, I don't know, your dermatologist was found to have a breach violation where they've lost records, they were stolen or something happened that, just didn't look good from a PR standpoint, you might not want to go there. So statistics have shown that once a breach violation occurs, 50% of the patients don't want to go there. I mean, you remember the dentist that shot the lion in Africa? Many of you may have remembered that. You think that helped his practice? No way. His practice dwindled down. He's rebuilding it now. It was not good. So negative reviews on Yelp and other social media sites, it could be simple, like, I had to wait a long time to see the doctor, or, the front desk receptionist just seemed rude. It's probably not going to affect your practice too much, but there could be other things that are much worse. Most of the complaints on providers on social media is about bedside manner. So if you do come across a review that's not good about your practice, analyze it. Take your time before responding. It's always a good idea to let it marinate. Don't make a hasty decision and respond and inflame the situation. Take your time, evaluate it. It could be fake or misleading. If the review is really blatantly incorrect, then contact the review site, explain the situation, provide evidence as to why you think the review is incorrect. And you may be able to respond to negative reviews right on the site, respond professionally, try to diffuse all the situations. Even though you may be 100% correct, you're better off trying to diffuse the situation. Just happened with one of my clients. My client had a new patient come in. He charges a lot of money. I mean, that's what he does. He's allowed to charge. He charges $350 for his new patient exam. That's just for the exam and the history. No adjustment, no x-rays. That's a lot in most, throughout most of the country comparing. So he had the patient sign a form that they're financially responsible. Patient came in, the patient knew it was $350. At the end of the visit, the patient paid the $350 and left. Next day or a couple of days later, the patient's very upset, angry, wants money back, feels that she was overcharged, and the doctor started to battle the patient, and then it started to get inflammatory. It wasn't diffusing. It started to get worse. The patient started to threaten, I'm going to, give you a negative review, I'm going to blast you on social media. So even though the doctor was right, doctor did nothing wrong, I recommended he give the money back to the patient. He didn't want to, but I asked him, Doc, do you want to continue battling or do you want to make this go away? He thought about it. He's like, Marty, I just want to get this. It's stressing me out. I just want to make it go away. I said, and give the money back to the patient, even though you didn't do anything wrong. That was my recommendation. So if the patient is really unhappy, you might want to respond privately on social media, show compassion, sincerity. I know you may be, you may want to have the urge to sue the patient because, they're putting on this negative review that could be detrimental to your practice. You might want to sue them. Yeah, I mean, get an attorney on that. Have good policies in place regarding your policy on, telling staff members that they can't friend their patients and they can't do this and they can't do that. Get a labor attorney to review your office policies to make sure it's appropriate and legal in your state. Remember, I'm not an attorney. There's certain things here that you need to get an attorney to sign off on. Have good policies and procedures and forms in place. Create a good policy manual, whether it's digital or paper, it doesn't matter. Here's a sample policy on EPHI, the technical safeguards that need to take place. It's just one page out of a HIPAA policy and procedure manual. Here's another page. This is a form. This is a patient coming in and saying, I want to restrict you from giving my information to anyone. So we have a form for that. There's other logs, like a patient might say, I want to know who you've given my records to. I want a complete accounting of all the doctors that you've sent my files to. So here's a information log. So to summarize, start, if you want to get HIPAA compliant, and even if you do consider yourself HIPAA compliant, every year you have to reevaluate what you're doing. So my recommendation is start with a risk assessment, designate a compliance officer. Doctor, you don't have a staff member that you think could handle it? Doctor, you become the compliance officer. If you have a trusted workforce member that's been with you for a while, could handle this stuff, then designate him or her your compliance officer. Make sure you have written. See, just saying, well, I'm quiet when I talk to patients. My staff has the patient sign notice of privacy practices. We keep our file cabinet locked. So I think I'm HIPAA compliant. No, 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 no. That doesn't mean, that's maybe you're on your way to be HIPAA compliant, but just having a locked filing cabinet and a notice of privacy practices does not make you HIPAA compliant. You have to have written policies and procedures. You have to have formal staff trainings. You need to identify your business associates. A business associate is somebody that's looking at your patient's protected health information that's not an employee of your practice. Like, who is a business associate? Who could possibly be a business associate in your practice? Well, a billing company, your software company, outside consultants, somebody that comes in to shredding your paper charts. You may have a staff member that's an independent contractor that's working at home, and that person is logging into your computer and helping you out with the billing. All of these people are considered business associates. If they have a breach on their end and it ties back to you, without a business associate agreement, you're held liable. So make sure you identify who's a business associate agreement, who's a business associate in your practice, and get them the updated business associate agreements. They were updated in 2013. Have formal staff trainings, log trainings in your procedure manual, and you should be updating your notice of privacy practices as changes occur in HIPAA and in your practice. So just a few closing comments. Please check with the carriers or your state board or an attorney prior to submitting claims and using the information provided in this presentation. We can't guarantee that the information in this presentation will guarantee payment from an insurance company or a patient. or prevent a HIPAA violation. Check with a labor attorney prior to implementing certain staff policies. Target coding is not responsible for any insurance carrier or managed care or any organization laws, rules, regulations, guidelines that may change following this presentation. And you know things change all the time. So it's important to do your best to stay on top of any changes that may occur by attending seminars, webinars, becoming a member of Target Coding, and joining your national and state professional associations. Now, Natasha, are you there?
I'm here. Hi, everybody.
Yeah, I'm going to have you come on in and share a few more things about target coding before we get to questions and answers.
Great. Hi, everyone. My name is Natasha. I'm Dr. Kotler's assistant here at Target Coding. I just want to tell you a little bit about what we do and what we offer. We offer a range of seminars, webinars, services, consulting services, memberships. So you see on your screen here is some information about some of the courses that we offer. We have many different classes. If you are on our Target Coding website, you can find these listed courses on our products page. We also have live webinars like you're listening to today. We have one coming up. Our next one that we have coming up is going to be on managed care. That's going to be on Thursday, March the 24th. So if you're interested in that, you can find that on our webinars page. So you see a list of these classes here that you're welcome to purchase or log in live if you're interested in that, or you can also get the recordings. We have those always available. Dr. Collar, if you don't mind going on to the next slide for me. So Target Coding offers a range of services, and one of my favorite services that we have is our Smart Choice program. You will see here it says, do you swan? Do you sleep well at night? This is a great program that highlights a great way for you to basically have a report of findings as to what you are doing in your office. Do you have things in place to help you prevent an audit? Do you know how to collect cash from a patient properly? Do your notes show medical necessity? Have you updated your fee schedule? Or do you have a dual fee schedule? All these types of questions that might be keeping you up at night are a great way to have Target Coding assess them, especially now with ICD-10. Are you diagnosis pointing correctly to maximize your reimbursement, and also do your notes reflect that? So if you would like us to do an evaluation like that, the Smart Choice program is a great option for you to get a handle on what you're doing in your office and if you're doing them correctly. So if you have some questions about that, you can always contact me directly at 1-800-270-7044, and I'd be happy to go over how that program can help you. Okay, Dr. Kotler, the next slide.
Okay.
Now, Target Coding offers a range of memberships, and we have memberships starting at $99 a month, and they go on up. Our memberships offer unlimited question and answer support, which I think is a great value to any office. So if you have questions that come up, I'm sure, on a daily basis that have to do with billing, coding, compliance, you can go ahead and contact us, and we're here to answer those questions for you. You'll see that the memberships have a range of access to webinars, to seminars, things like that. So depending on what level you would work for your office or what you're looking for, you can choose one of our memberships, and we're here for you, to help you with anything that you pretty much need. So if you need help picking a membership or are looking at maybe a certain membership that might help you, I'm here to help you evaluate that. But one of our best memberships that I think every office should have is our basic membership. This one includes unlimited question and answer support via email. It also includes unlimited access to our live webinars, and you also receive discounts on our classroom seminars, our DVDs and training manuals, and any recorded webinars that we have. It also has all of our updated chiropractic billing and coding updates that we include for you. This membership is $99 a month. You can stop at any time, so it's a great way to have us at your fingertips. You also see our bronze membership. That's a level on up. That also includes the unlimited question and answer support. And as you move up in our memberships, they include additional items. So, you know, the gold membership is also another great one. That one includes a comprehensive review, which I think is an amazing option to have if you want us to review your notes and your intake forms and do some training with your staff and just basically hold your hand through the process of getting you compliant and helping you with your billing and coding. Okay, I also want to mention we have some seminars coming up with CE credits. Our next upcoming seminar is going to be in Newark by LaGuardia Airport on on April the 7th. So if you're interested in attending that, feel free to give us a call, or you can register straight on our website through our seminars tab. We will also be having a seminar on personal injury in Florida, in Fort Lauderdale, on April 21st. The seminar does not have CE credits, but it's packed with great information on personal injury and cash patients if you're interested in that as well. I also, if you've never been part of our newsletter list and you got this information forwarded to you by a friend or a colleague, definitely I encourage you to join our email newsletter list. We send out tons of great information for you guys. We also keep you updated on current things going on in the industry, and also you'll be privy to any special webinars or seminars that we have coming up, like the one that you're on today. If you have any questions or need to get a hold of us, you have our information up on the screen, or you can always contact me directly at the 800 number listed here, or at natasha@targetcoding.com. That's Natasha at targetcoding.com. Thank you so much, and I'm going to give everything over to Dr. Collar to answer your questions today.
Excellent. Thank you very much, Natasha. So again, I want to thank everybody for attending. Our contact information is on your screen. General email is info@targetcoding.com. Website is targetcoding.com. Telephone number 1-800-270-7044. Again, I thank you for attending, and I hope you learned a lot.